Hello, everyone. In business, there are many cases where a person invests money in a company, receives profits for many consecutive years, but does not have their name on the business registration document. So, when a dispute arises, does that person automatically become a member of the company? The precedent number 78 of 2025 from the Supreme People's Court has guided this content. Let's follow along. In this case, Company LLCD was established in 2001 with two members, Mr. Nguyen Van T and Mr. Tran V. At that time, the company needed additional capital to expand its production and business activities. Mr. Tran Man H, who was living and working in the Czech Republic, was invited by Mr. T and Mr. V to participate in the capital contribution. Subsequently, Mr. H transferred a total of 2,751,218,000 Vietnamese dongs to the company. For many consecutive years, Mr. H received profit shares from the company's business activities, with a total amount reaching several billion VND. By 2017, the parties recorded a memorandum confirming the amount each person contributed to the company. According to this memorandum, Mr. H contributed over 2.7 billion Vietnamese dongs, and the company's profits will be equally distributed among the three individuals. However, Mr. H's name does not appear on the business registration certificate or the list of company members. Therefore, Mr. H filed a lawsuit requesting the court to determine that he is a member of the company with an ownership ratio equivalent to one-third of the capital contribution. When considering the case, the Council of Judges of the Supreme People's Court determined that company TNHHD was established before Mr. H contributed capital. Throughout the operation, the business registration certificate only recorded two members, Mr. T and Mr. V. Although Mr. H contributed capital, there is no documentation showing that the parties agreed to add Mr. H as a member of the company. There is no agreement to increase the charter capital. There are no procedures for registering changes in members with the Business Registration Authority. There is also no content indicating that Mr. H is responsible for the company's debts and property obligations as a company member, according to the provisions of the enterprise law. The special court emphasizes that contributing capital to become a company member and contributing capital for joint business operations are two completely different issues. In this case, the documents only show that Mr. H contributed money for joint business operations and received profit sharing. There is no evidence to prove that this monetary contribution was intended to increase the charter capital or establish membership in the company. Therefore, Mr. H cannot be automatically regarded as a company member simply because he contributed money. Thank you all for your interest and support. If you find this video helpful, please share it so that more people can know about it and refer to it. See you all in the next videos.